Well, good morning, everyone. Today is Thursday, September 24th, and we are going to go ahead and call this Health and Human Services Committee session to order. And we are going to be discussing two items today. First, Bill 2820, Human Rights and Civil Liberties, Discrimination in Public Accommodations, LGBTQ Bill of Rights. And second, Bill 1420, Human Rights and Civil Liberties, Discriminatory Employment Practices, Workplace Harassment. And I am really, today feels historic on a number of different levels. This council has taken up issues of equity and has been a real champion on a number of different levels. And it has been truly an honor and privilege to serve with all of you through this inflection point that we find ourselves in our country and in our world. And Bill 2820 is an incredible bill, led by my colleague and friend, Councilmember Evan Glass, but co-sponsored unanimously by all of my colleagues. And before I go any further, I want to turn it over to my colleague and, more importantly, my close friend, Councilmember Evan Glass, to make some opening comments regarding this very important bill. Councilmember Glass.
Well, thank you very much, Mr. Chair. I appreciate the kind words and sentiment, and I share them and am very appreciative of your support, Councilmember Rice's support, and all of our colleagues who have signed on unanimously to co-sponsor this piece of legislation, the LGBTQ Bill of Rights, because as you were just noting, our role as elected officials here in Montgomery County is to make sure that everybody feels safe and protected. And there are a number of ways that we can do that. And the times that we are in right now, all safety measures and all ways to preserve individuals' rights and dignities are at the forefront. And so here with this particular piece of legislation, we are working to make sure that LGBTQ plus members feel safe and secure, and that nobody should be made to feel different or discriminated against because of their actual or perceived gender identity and HIV status. And what this bill does very succinctly is provides meaningful support for LGBTQ plus members of our community, and in particular seniors, which is a fast-growing demographic here in Montgomery County. We have discussed it at length here in the HHS committee and as a council as a whole. And with this piece of legislation, healthcare facilities, nursing homes, and personal care facilities would become more safe and welcoming for all residents. And so I'll conclude by again thanking all of you, my friends and colleagues, and also to the organizations throughout the state and throughout the DMV who are supporting this piece of legislation, including the Maryland AARP, which has provided some really insightful data about the changing demographics in Montgomery County and the state, as well as Westmoreland Congregation, United Church of Christ, and a number of other LGBTQ plus organizations throughout the region. So I look forward to this conversation on this bill.
Thank you, Councilmember Glass. And we have a great packet, once again, prepared by Ms. Wellens. And we also have in the audience Office of Human Rights Director Jim Stowe, who is here to answer any questions that we may have. So I will now turn it over to you, Ms. Wellens, to walk us through the packet.
Thank you, and good morning, Mr. Chair and council members. So this bill, as Councilmember Glass articulated, brings in some new definitions to the human rights law by Chapter 27 of the Code, by specifically defining gender expression and also identifying HIV status as a protected class of individuals that must not be discriminated against in public accommodations. And as Councilmember Glass said, in particular, it hones in on the issue of care facilities, including nursing homes, and articulates some specific actions at those locations and at other, public accommodations that would be considered, that would be deemed discriminatory acts. And I'll try to just identify them quickly. Those types of actions include denying admission to a facility, based on any protected status, but particularly including the gender expression and HIV status, denying a request by individuals to share a room in a facility. If rooms are assigned by gender, refusing to assign a room to a transgender individual other than in accordance with the individual's wishes. It prohibits willfully and repeatedly using the wrong pronouns for an individual after you've been clearly informed of what the correct pronouns are, and the individual's name, intentionally and willfully using the wrong name, denying the individual the right to wear or be dressed in the clothing and accessories that they choose, restricting the right to associate with other individuals, denying or restricting medical care, and providing medical or non-medical care in a manner that to a similarly situated reasonable individual would unduly demean the individual's dignity or cause avoidable discomfort. So that's kind of the crux of the bill, and it's enforced by the Office of the Commission on Human Rights under Chapter 47 of the Code, in accordance with their general enforcement powers. In terms of issues identified for you in the staff packet, the Office of the County Attorney articulated a couple of legal concerns with the wording of the bill, in that they were concerned that some of the wording might be vulnerable under the First Amendment, might be considered compelled speech under the First Amendment, and thus vulnerable. And the County Attorney's Office suggested a couple of relatively minor amendments that I think, mitigate the concerns, don't change the substance of the bill. And the first issue relates to the posting of anti-discrimination notices. The bill as originally drafted required notices essentially stating that the facility does not discriminate upon these various bases. And the County Attorney's Office said, instead of stating that the facility doesn't discriminate, instead the bill should state that the law prohibits discrimination based on those factors. So it's a little more, it's a little more precise in terms of it informing people of what the law provides, and avoids concerns on the First Amendment. So I think that's certainly reasonable to want to make the bill as defensible as possible, but without changing its substance. So that's pretty much the first issue.
I don't have an objection to that, Councilmember Glass.
No, that seems like a reasonable legal tweak.
Okay, so without objection, we support the amendment.
And the other legal tweak would be at item number 2 of the staff memo regarding the use of pronouns. And again, this is a compelled speech issue. The way, as originally drafted, the bill prohibited willfully and repeatedly failing to use an individual's name or pronouns after being clearly informed of the name or pronouns. So the recommended amendment by the County Attorney's Office, they wanted to add in sort of an intent factor that it would be illegal to willfully and repeatedly, with the intent to humiliate, fail to use an individual's name or pronoun after being clearly informed of the name or pronoun. I believe that our council staff, would suggest even a tweak on that, which I think would might be better in terms of just flat out avoiding the compelled speech argument, which would be just to tweak the language to say that it's illegal to willfully and repeatedly use an individual's incorrect name or pronoun after being clearly informed of the correct name or program. So that would be it. That would be saying just like in the context of, sexual harassment or other types of prohibited harassment, you can be held accountable for your words, for calling people derogatory names, for example. So I think this tweak in the language will put this in the same category of, if I was working in a facility and I've been informed of someone's correct pronouns and correct name, and I am willfully and repeatedly using the wrong ones, that I should be held accountable for that. So that the decision point there is essentially whether you'd like to leave the language as originally drafted, amend the language as recommended by the Office of the County Attorney, or amend it as I was just trying to articulate.
Has the Office of the County Attorney, Ms. Wellens, reviewed the amended language that you and our team have proposed?
That's a great question, and I meant to affirmatively check in with them. I did send it to them about a week ago, and I hadn't, I sent it to the drafters of the memorandum and had not heard a concern back. What I could certainly do is just make sure, after this work session, kind of prompt them to give me let me know if they have, let me know specifically if they have a concern before there's a final vote. I feel fairly confident about it because I just don't see that with this language that I don't see how there would be a compelled speech argument. But I can certainly follow up on that. I'm sorry for not having the answer to that.
That's okay. I think, on the surface, I don't personally have an objection to your amendment to the County Attorney's Office's amendment, but ensuring that this is put in the best position to succeed and is obviously paramount. And so I think two heads are better than one on this one. And so while on the surface I'm comfortable with what you've proposed, I want to defer to my colleagues to get a sense of where they are, but I think we could move it forward pending the confirmation that the County Attorney's Office affirms our council's guidance.
I'll jump in, and I think you framed it correctly, Mr. Chair, in that the intent of this particular clause is to ensure that if there is hateful or harassing speech, that it could be rectified, through the court or through administrative action here in the county, and whatever puts an individual in the best position to seek justice and to feel safe in that facility, I'm fully supportive of. And so also being a strong supporter of the First Amendment, don't want to abridge anyone's rights, but want to make sure that everyone is respected. And so I think what you said, that the amendment to the amendment makes sense, but agree that let's just confirm it with the county attorney.
Mr. Chair, I agree with that wholeheartedly. I think that, again, that puts us in the best spirit. Again, what the spirit of this bill is, and really want to thank the leadership of Councilmember Glass, is to make sure that people feel comfortable and welcomed, supported and respected in our community. And so from that perspective, however we can accommodate and accomplish that while at the same time adhering to the tenets that we have in place legally, is the right way to go. So thanks.
And our colleague and friend, Councilmember Jawando, has joined us, I believe, here to discuss the second bill, which he is the lead on. But certainly, Councilmember Jawando, if you have any comments at any point during this particular discussion, please feel free to let me know, and we'll include you. Okay, so does that seem clear, Ms. Mullins, then? So we will move then, without objection, your proposal for the amendment to the amendment, but still, when it gets to full council, we'll want confirmation that the county attorney agrees with your assessment. Okay,
absolutely. I'll confirm with them. Thank you.
Okay. Now I want to turn it over to Mr. Stowe. Mr. Stowe, as we all say, you've got a lot of fans on this council, and we all very much respect and appreciate your work. We are adding to your plate, it seems, daily, but the work is clearly so important. Mr. Stowe, if you wanted to make any comments regarding this particular bill and any perspective that you would like to bring, and we appreciated you sharing the comments of the county executive and his strong support of this bill during the public testimony. But Mr. Stowe, I turn it over to you.
Thank you so much, Mr. Chairman, and to all of you, thank you also for your support ongoing for our work. And also, I need to say this as well in terms of how I believe that this council has improved the quality of life for all of our residents who live in Montgomery County with the number of bills that have come forward and efforts on behalf, even though it has a direct impact on our ability to perform and to execute. I believe, though, that the spirit for which this is being offered is just tremendously important for our community. So I thank you all for this, and certainly Councilmember Glass specifically for this bill. One of the things I think is important to note is that this really extends beyond just what's been actually identified here. One of the issues that often arises, particularly within our trans community, is the importance of that use of pronouns, and particularly when it relates then to issues for which they find themselves in needing, requiring, or requesting services. And so there is in my opinion, a massive education that has to be done, not only to those that are identified appropriately in this bill, but just in general around that particular community and other communities in general within the LGBT plus community. But having said all that, it goes back to, again, the issue from our perspective of getting and providing the kind of environment where we have folks and residents within this community come forward and file the complaint. That will drive, obviously, what we'll need to do in terms of additional staffing, et cetera. But we are going to work harder on creating the kind of environment that has persons step out. And I'll go through with this because it is a process. It is a process. And persons are putting themselves out there in this process as they kind of go through from beginning to end to get a decision. So we say all that to say this, is that we are certainly very supportive of this. It will require us to dig a little deeper in terms of, again, this public education effort for those that are named in this particular bill, as well as those who are not. I should share just very quickly that the housing concern is one that we've been dealing with for some time now, particularly involving senior members of this community. There are some real issues there as they begin then to try to find housing, particularly as it relates then to housing that's set aside for seniors across our community. And so that's yet another issue. The other issue, of course, is as first responders arrive on the scene and attending to a person, particularly those who are trans, in terms of how they deal with that individual and trying to help them, how they are addressed. Again, the pronouns are critically important. So at any rate, great first step. This whole idea about the Bill of Rights, I think, gives us the opportunity to sort of put that out there and say to persons, this now really ties into the rights of every individual who lives in Montgomery County. But there are some very specific issues that need to be addressed for this particular community. And I'm so glad then that this does this. And we'll certainly do all we can to do that in terms of dealing with complaints in the sensitive kind of way as they come through our office, as we try to do for all of our residents. So I'll stop there and just have that be, again, this additional comment. I do want to underscore, then, again, the county executive's full support of this bill as well.
Thank you, Mr. Stowe. That was well said. I do think that we have an opportunity here because through our Office of Aging and Disabilities within the Department of Health and Human Services and the state, there's a regulatory aspect of this. And so we know these organizations. They have to go through a licensing process. And so there's been a relationship built, and that will put us in a better position as we educate the community and the key partners. And the timing of this is really extraordinary. With the pandemic and COVID, we have seen repeated instances of challenges of family members trying to access loved ones within facilities. And so this will, the timing is great because as we continue to go through the pandemic, we want to eliminate all barriers to ensuring that all of our loved ones have access to their family and friends and everyone that they need to support them through these difficult times. So I think, Ms. Wellens, we've covered our bases here. I will note, as we typically do when talking to Mr. Stowe, the budget issue and capacity issue. But I do think in this instance, with a partnership with HHS that will put the Office of Human Rights in a better position than maybe some of the other bills we've been able to pass to partner and on the regulatory aspect of this. But nevertheless, we need to bear in mind that they have a lot on their plate, particularly during this time, and that has to be under consideration as well. So, Ms. Wellens, was there anything else regarding this particular packet that we needed to cover this morning?
No, Mr. Chair. Thank you.
Okay, then can I get a motion to move forward the bill to full council as amended?
I move.
Second.
Second. All those in favor, please raise your hands. That is unanimous.
Thank you.
Thank you. And Mr. Stowe doesn't have to go far. We are now going to discuss the second item today, which is Bill 1420, Discriminatory Employment Practices, Workplace Harassment. The lead sponsor of this bill is Councilmember Jawando, also unanimously supported by all of my colleagues. With that, I will turn it over to Councilmember Jawando to make some opening comments regarding this particular bill. Councilmember Jawando.
Thank you, Mr. Chairman, and if I could have voted on the last bill, I would have as well, but I will congratulations to Mr. Glass and to the committee. Very important legislation that I'm proud to co-sponsor, and really glad that it's going to move forward, and glad that it's paired with this other piece of important legislation that we're going to talk about now. So thank you, as always, to the HHS committee and Director Stowe and Ms. Wellens. As you said, we're seeing you daily here, but it's for good reason. I actually introduced this bill during Women's History Month, and obviously we're in the 100th anniversary of women demanding the right to vote. And while this doesn't just address harassment and sexual harassment for women, we know that there's disproportionality. 81% of women and 43% of men have experienced sexual harassment, according to a 2018 NPR report. Those are significant numbers, and I think often we forget how pervasive this issue is. And I use the word pervasive intentionally because the thing that this bill fixes is it changes the standard and actually makes it a reasonable standard for when you can claim and have protection for workplace harassment or sexual harassment. And the current case law standard is that it has to be severe or pervasive. And we have seen, and I've spoken to folks, and we heard from folks in public testimony, that where significant harassment has taken place, but that standard was not seen to be met by a court, and there was no remedy. And obviously, the Me Too movement has brought this issue to the forefront, in a positive way, in that bringing things out of the dark that were happening, that people knew were happening, but that we weren't talking about. And so this bill is to make sure that there are clear definitions for harassment and sexual harassment, removes the severe or pervasive standard, and allows allegations that, quote, have a reasonable victim of discrimination would consider conduct to be more than a petty slight, trivial inconvenience, or minor annoyance. So it's still at a reasonable level, but something that can actually meet review upon an investigation or a judicial proceeding. So the goal here is that we want workplaces to be professional, welcoming, and where people can feel like they can use their gifts and grow and contribute to our economy. And so I won't go through the whole bill. Ms. Wellens can answer any questions, but that's the basics of this, is to make sure that there's not an unreasonably high standard for people who experience workplace harassment or sexual harassment. And finally, I just want to thank Council members Navarro, Glass, Albornoz, Hucker, Katz, Reamer, and Rice. And I'm not sure if maybe Friedson was added after we wrote this, but for co-sponsoring. And I hope that we can move this forward and make sure that we have the added capacity for Mr. Stowe so that they can move this forward and enforce it as well. So thank you very much.
Well, thank you. Ms. Wellens, if you could also walk us through this packet too.
Yes, I'd be happy to. So, Councilmember Jawando thoroughly explained the bill. I'll just, if it's okay, hop into the items that were noted for you in the staff report. So, the first issue, and Councilmember Jawando already really touched upon this, but is the fact that this bill, just highlighting for you the fact that this bill is moving away from what the courts have termed a severe or pervasive standard for bringing hostile environment employment law claims. And so most jurisdictions for a number of decades have used this severe or pervasive standard. And the county attorney's office submitted a memorandum, which is included in the packet, which highlights the point that departure from this standard, can result in more liability exposure and legal costs for employers, including the county government itself. I think employers also would need to incur the cost of updating their training, although hopefully their training already, instructs people not to harass others, even if it's not, doesn't rise to the level of being severe or pervasive. I think it's also important to note that in OLO's economic statement, they did not feel that this would have, a significant economic impact on private organizations in terms of the council's priority indicators, namely workforce, operating costs, capital investments, property values, taxation policy, economic development, and competitiveness. And then I also think it's important to point out that sexual harassment itself and other forms of hostile work environment and workplace harassment has a steep economic cost itself. In the staff report, there's a reference to a study by the consultant Deloitte, which found extensive costs, $2.6 billion in lost productivity in 2018 in Australia. Some of the information in the U.S. is frankly not as comprehensive, but I think it's common sense that when someone's being abused, they're not going to be as a productive worker, and they're going to incur costs, financial costs of their own. So that's really, there's not a proposed amendment under this item. It's just, wanted to emphasize to the committee that this is a significant departure from the standard that has been used for a long time, as Councilmember Jawando already noted. Thank you.
Thank you. I don't see any questions or comments from my colleagues on the committee. I think we need high standards here. That is critically important. And I am sensitive to the possibility of additional costs incurred regarding training. But as Councilmember Jawando noted, this is an important moment in time. And I think that we must remain vigilant and leaders in this and so many other spaces. And it's in companies' best interest, organizations' best interest, to ensure that they provide a work environment that ensures the highest possible standards of safety. And so that all feel comfortable being able to come to work every day. So I understand this is a transition and a departure, but I think it's an appropriate one. Mr. Stowe, did you have any thoughts or comments regarding this specific item? And I know that, quite understandably, you often have the opportunity to hear from our businesses and organizations as we put forward important pieces of legislation. Is there anything we should consider here on this particular point? And it looks like you may have frozen, Mr.
On this item, Chairman, I think that, again,
Oh, Mr. Stowe, if you could start over again. Looks like you froze a little bit there.
Okay. Mr. Chairman, again, I want to thank you for this opportunity to be a part of this discussion as well. and then to Councilman Jawando. Thanks for his leadership in this area on this specific issue, and particularly this item, item number 1. We were pleased to see it because one of the issues that we stated in our testimony was that many persons, particularly females, males as well, but females primarily, find it very difficult to, in fact, reach this bar that has been established for some 30 plus years in the workplace. And so what this really does is begins to get at ongoing level of activity and harassment that is occurring in the workplace around this issue of sexual harassment, and gone pretty much unabated because persons feel like there's no use to coming forward because it's going to be their word against mine, et cetera, and therefore the actual complaints that really need to be dealt with don't come forward. I will say, however, in the last 3 to 5 years, the complaints we have dealt with in this area have been severe and pervasive. For whatever reason, there seems to be some sort of, I'm not so sure what is going on in the workplace, and this is not obviously predominant in all the workplace, but in some areas, a return to some behavior that I thought we had long since passed, where harassment is a real issue, sex harassment specifically, in some workplaces. So what this will do, hopefully, is allow persons who are feeling this particular issue occurring in their workplace and their work setting to come forward, now realizing that if the behavior has been consistent and ongoing, and in this case persistent as well, then they've got at least a route to kind of air that grievance, have it come forward, and have someone like ourselves come in and do some sort of evaluation, assessment, whatever the proper term is, to look to see if there is, in fact, harassment that can be substantiated in that work setting. So I think it's an important piece. I'm glad the bar has been lowered. I think it's been lowered only to really be more in line with what is actually happening in the workplace.
Thank you, Mr. Stone. So I think without objection, we can move on to the next item in the packet.
Thank you. So the next item in the packet relates to the definition of harassment. And as you know, this bill places definitions of harassment and sexual harassment in the code, whereas previously we have not had those definitions set forth in the code. It wasn't that those things are not already illegal, but this kind of sets forth clear definitions. And in connection with that, the County Attorney's Office memorandum pointed out that there's a difference between, sorry, I'm not going to, let me start a little bit again. So under sexual harassment, hostile environment claims, they're kind of under the current law and also under the bill, there would be subjective components to that and objective components in terms of as the victim, whether the victim subjectively is perceiving the environment to be hostile and perceiving harassment to occur, and also whether an objective person in the same situation would perceive harassment to be occurring. So under the bill as it's formatted, you could have an individual who perceives that they've been the victim of a hostile work environment. They could move forward with their claim. They would also have to show by an objective standard that an objective person in the same situation would find the conduct to be more than a petty slight, trivial inconvenience, or minor annoyance. So that's the current bill. If the committee wanted to, it could kind of import the objective test into that first hurdle, in which, so that you would say that the victim, it wouldn't be enough for the victim simply to perceive that there was a hostile environment. The victim would have to reasonably perceive that. But then you'd still go to the next step, on that first step, you'd still go to the next step of having to show that an objective person would find it to be, to find the conduct to be more than a petty slight, trivial inconvenience, or minor annoyance. So, and I might be creating unnecessary confusion here because the County Attorney's Office didn't actually propose an amendment to this, but I put forward an amendment in case you wanted to make the standard a little bit higher in terms of like what the plaintiff would have to prove in this particular, in the kind of the first step of proving the harassment. And I also wanted to add, to supplement what's in the staff packet, by letting you know that the definition of sexual harassment that is in the bill was modeled on the definition that's in Maryland state law for purposes of mandatory sexual harassment training for state employees. So I think that's, relevant to the extent that, it's, when we can, probably often helpful to have consistent definitions between the local and state level. And also, there already is, as the bill's written, there already is this objective standard and subjective standard. So I don't think that an amendment is necessary, but that is one option for the committee. Thanks.
Councilmember Girondo.
Thank you, Ms. Wellens, and thank you, Mr. Chairman. I would obviously prefer to keep it the way it is. I think, to Director Stowe's point, it was a perfect precursor that I think there has often been a chilling effect because of this high standard, that many people haven't come forward or don't think that the hoops are going to be too high. And I think we want people, as a policy matter, to, if they subjectively feel that they've been harassed, we would like them to come forward and put a complaint forward. That doesn't mean it's going to be found to have been harassment. I think the secondary step of an objective person would reasonably believe that it was more than a petty slight. The standard that was described, that's an important check. But I think just making sure people get into the door to correct the system we're currently in would be where we want to be, and not have that objective standard in that first step. So that I just wanted to say that. Thank you.
I agree. I did have a question. I see your hand, Councilmember Glass. I'll get to you in 1 second. I don't believe that this particular part needs to be amended. That's my opinion. But there are, if there is a false claim, the person who has the false claim made against them also has rights to some degree. And so, Mr. Stowe, could you talk about if there has been a harassment case brought, it's investigated, and it's found that, in fact, it's not only not valid, but there was harassment by the person who claimed harassment for some reason. Could you talk a little bit about, because I understand where Ms. Wellens is coming from, but people have rights on both sides.
Yes, Chairman, I think in this instance, you have a situation where what our actual reality has been thus far is that part of the analysis to the case today, that we at least believe today, has to go through some comparables and some analysis. And so we have to put forth a pretty stringent test right now on how we would in fact move to forward on a given case. And if at any point along the way we believe that for whatever reason, I'm sorry, my video went away here for a second here.
I think your audio was coming out. Sometimes when you take the video off, it improves the audio.
That must be what's going on then. Mm-hmm. Well, you've already seen me, Mr. Chairman, so I'll move on. So the point I'm making is that I think in that analysis process, we oftentimes will come to a point where if the facts don't support the allegation, at least from our perspective, that matter does not go forward, at least through our process. Obviously, she could go to their own private counsel and move forward if they thought, for whatever reason, we did not adequately look at their particular case. But that analysis is going to happen anyway to determine whether or not that case has a full merit. What now you are allowing in this bill is to have us at least get a chance to do that analysis. Because right now there's some persons I suspect who are not coming forward at all because it's just, for their point, something for which is just going to be just a waste of time. And so I think that even with the case where one does come forward and just say that their particular case does not somehow or another meet muster in terms of what we need to be able to substantiate in our analysis, what you simply have is a case that becomes, again, no probable cause. Mm-hmm. And so no harm, no foul in terms of that situation. Now, in terms of what happens when that employee goes back to the environment that they in fact have come from, with having maybe in the minds of the employer put forth a frivolous case, that may create some challenges within the workplace itself. But we also have evidence of a retaliation claim that could also come forward on behalf of the employee for having filed the complaint, however it would turn out, again, substantiated or not. So in this instance, I think that we are fine as it is, because I think the assurance, at least from the county government is concerned, we're going to do the analysis, we're going to do the kind of really make sure that we've got in place the components that are necessary to actually prove the case, or at least, again, to the extent that we believe it has violated our human rights law. So we'll, in that analysis and in that whole process, we'll be able to determine whether or not we've got something that's, again, meets all of our particular requirements to go forward. So I think that fail-safe is already in place, in my opinion.
That's very helpful. Thank you. Councilmember Glass.
Yeah, I think my question was answered by the smart discussion, but I'll express the concern that I had, and it was with regard to this specific provision, wanting to make sure that we weren't setting people up to fail, to voice their concern, voice their complaint, but not having it meet that threshold if we're to go to court. And I assume that is what Ms. Welland was articulating as why she introduced the amendment, but it sounds like Mr. Stowe and the sponsor, Mr. Jawando, think that lowering the threshold for voicing one's thoughts or voicing one's concerns about their workplace is the more important component to this. Am I understanding this correct?
Yes, from my perspective, yeah, and I think yes, because you want people to come forward, and we don't want to, and you don't want to suppress it. I think Director Stowe said it better than I, but yeah, I would agree with that.
Okay.
Okay, thank you. Then I'm satisfied. Thank you.
Great. So then.
Oh, I did want to say one thing, and I often, in these cases, if there is a false claim, just like with any, defend the lawyer, if it did go to court, or if the lawyer needed to be retained by a defendant, you can always ask for attorney's fees to be paid if the case is thrown out. So there are some built-in remedies already in the case of false claims.
Okay, so I think without objection then, keeping the language as was written in the original bill seems like the will of the committee. All right, next, Ms. Wellens.
Great, thank you. And also just to reiterate the points already made by Director Stowe and Councilmember Jawando, there certainly is, ample due process for both parties at the administrative level, and then also when they get to court. And I do think that, frivolous claims would be weeded out with this new standard under the bill. In terms of the third point in the staff report, in some ways reiterates the prior points, just to emphasize that, Montgomery County, if it adopts this bill, will really be at the forefront of moving away from the severe or pervasive standard. There are some states that have pending legislation to do the same thing. The state of New York already has done this. They already have moved to a standard that's more protective for workers, similar to what this bill would do. California has issued guidance essentially to its courts to try to move away from the severe or pervasive standard, although they didn't make it mandatory. And these laws are very new, so we don't really have the case law to see, how have courts really sorted through this. Although I suspect that if Montgomery County passes this bill, that our courts will end up at least initially looking to some of the New York State courts and how they're interpreting their similar law. This third point was that, there's no amendment associated with it or proposed amendment. It was just kind of giving you the lay of the land in terms of where other jurisdictions are, and it also points out a sample of a case in which the severe or pervasive standard was really, I think, arguably
just really did not serve justice. There are examples of cases. Obviously, these cases are very fact specific to begin with. But there are plenty of examples of where the severe or pervasive standard has kind of cut short a case that maybe really should have gone to a jury. Thank you.
And Mr. Chairman?
Yes.
I just think this is really important because I think some people, like I always like to say, the millions watching at home, this example of Swire or Swire versus Fair Food Corp. The Court of Appeals held for the employer and found that there was no severe or persuasive harassment when during an overnight business trip, a sales representative followed his female colleague into her hotel room, got into her bed, and said he wanted a cuddle buddy and asked her to go skinny dipping. She reported this behavior, and he was not reprimanded at all. And in fact, she was fired a month after she complained of the abuse. Nonetheless, the court found that there wasn't actionable harassment. And I just think it's important to, as Ms. Wellen said, they're very fact specific, but if you listen to that kind of story and what a court determined, you can't help but see that standard that's not appropriate and obviously should be found to be sexual harassment. And I think it's helpful sometimes to just give context to what we're talking about. So,
and I'll note, for important pieces of legislation like this, through the Council of Governments and our partners with neighboring jurisdictions, just as we did with the vaping bills, it sets a trend that then is picked up regionally. And so I think that this is an area, clearly given the moment that we are in, that I'm sure and confident other jurisdictions will look at closely. And given that there's precedent in New York, and moving this forward is not just the right thing to do, but also I think will bring other communities in as well. I'm confident in that. All right, Ms. Wellens, was there anything else that we needed to discuss with this particular bill?
I don't believe so, Mr. Chair. Thank you.
Great. So then could I get a motion to move forward the bill to full council as amended?
So moved.
A second.
Second. All those in favor, please raise your hands. And that is unanimous once again. Come back anytime, Councilmember Jawando. You're on.
I'm going to say, can we schedule something for tomorrow? This is great. I appreciate this. Thank you all again. Good to be with you.
Okay, thank you. And with that, we are adjourned. Have a good morning, everyone.